overdrawn director's loan account, but no personal assets. What's going to happen if your company goes into liquidation? Well, the answer is, let's talk about the liability and the other things that can actually happen to you as the director of the company. Let's assume it's a small one-man band type, SME type company, or relatively few people involved. Ultimately, if we just focus to begin with on the liability, if you do not have personal assets to enable you to repay the overdrawn director's loan account and the company goes into insolvent liquidation, the expression "you cannot get blood out of a stone whilst unfortunate" is nevertheless relevant. Ultimately, if you don't have assets, you cannot be forced to repay with what you don't have. Now, that doesn't mean that you can never be called upon to repay anything. If you have a substantial income stream, then it's conceivable that there could be an attachment to your earnings. For example, if a liquidator was to apply to court for such an order, it's not that common. Ultimately, when an individual is called upon to repay their overdrawn director's loan account, you will typically expect the liquidator to essentially be focusing somebody's mind on their ability to pay based, if it comes down to it, if the person doesn't have means and assets to repay. But the starting point is ultimately going to be their assets. Certainly, a person's income will come into the equation, but ultimately there will be a situation where a person's assets may quite commonly and not unreasonably be reflected from their income. So a person who has a substantial surplus income will typically acquire assets, and vice versa. So ultimately, what you may have is a situation where somebody who doesn't have substantial assets will not necessarily have a lot of surplus disposable income, and therefore the overdrawn director's loan account will potentially not get repaid substantially, or indeed in some cases at all. Now, in other instances, if we move on from the whole concept of the ability to pay the overdrawn director's loan account back, if the liquidator decides commercially it's not viable to pursue the director, then there are consequences, because if the overdrawn director's loan account is written off, then ultimately what happens is that will then get put usually on somebody's personal tax return as income through a distribution, and that can then be subject to income tax. And so an individual can all of a sudden find that they've got a substantial tax bill to pay, which they may not be able to pay, and that can then ultimately potentially progress and lead to their bankruptcy. Now, aside from that, there is something else to consider in the context of an overdrawn director's loan account when a company goes into liquidation, beyond the mere liability question or the subsequent tax consequence, and that is the question of the conduct. In other words, why did the overdrawn director's loan account arise in the first place? Was it because the director helped themselves to the company's money when they shouldn't have done, because the company, just needed that money for creditors, the company was insolvent, whatever? Ultimately, although it is not in itself the most common cause of director's disqualification by any means, it nevertheless, if a director has essentially hoovered up company funds inappropriately, that has culminated in an overdrawn director's loan account, then director's disqualification could potentially arise. Questions, queries, concerns, give us a shout. Winner Insolvency, Inside Out.